Hello and welcome to Calm the Pharm podcast, where pharmacy business meets legal wisdom, minus the headache. In each episode, we share practical legal tips and real-life examples to help you run your pharmacy with confidence. I'm your host, Sarah Stoddart. Thanks very much for joining us. Today on Calm the Pharm podcast, we're talking about personal guarantees. And these are guarantees or promises that are made usually to a bank or maybe a landlord or other third party by directors of companies or perhaps even third parties like spouses, parents and the like. They're important documents, personal guarantees and indemnities, and today's podcast is all about what you need to know. As a disclaimer, this is taken from an article which Molly Ferguson on our team Vitality Law Australia wrote and submitted to Retail Pharmacy. But it is important, I think, for our listeners to be across it as well, and that is the case regardless of what kind of business you are in. It doesn't have to be pharmacy, it's common across all businesses and indeed possibly in your life as well outside of business. So, pharmacists, although it can be anyone really, are often requested to provide personal guarantees for business loans, investment loans, or to assist family and friends in need. While providing a personal guarantee may lead to more favourable loan terms or interest rates, there are critical aspects you must consider before you sign on the dotted line. So what is a personal guarantee? It is a legal commitment where you, as an individual, make a promise to the lender, which is often the bank, to fulfill the borrower's loan obligations if they fail to do so. So if your borrower is ABC Proprietary Limited, you might be giving a promise to the bank as an individual that ABC Proprietary Limited will pay the loan, and if they don't, you'll fulfill their obligations. So if you provide a personal guarantee, a lender can look to you as guarantor for repayment of the loan, and that includes the outstanding amount, accrued interest, and any legal costs associated with pursuing you or the borrower. It isn't just the loan amount that needs to be considered, but potentially these additional amounts that could be sought from you. Guarantees must only be given voluntarily and never under duress. And if you do have any concerns about your obligations or the circumstances in which you are signing, you can refuse to sign. However, it's important to keep in mind that refusal to sign may provide the bank or whoever it is that is getting the security from you the ability to decline to provide the loan or to come up with another option for security. Amongst the biggest concerns with personal guarantees is the exposure of your personal assets. So if the borrower defaults on the loan, it's not just your assets that you had at the time of signing the personal guarantee, which might be, for example, home, car, or cash savings, that are at risk. Any future windfalls, such as lottery winnings, if you're that fortunate, and inheritance, artwork, wine collections, etc., or future homes that you purchase could also be pursued. So the guarantee is given at a point in time, but relates to any assets or belongings in the same name, so your name, that come into existence at any time after that and until the guarantee is actually discharged. It's vital to understand that this exposure, therefore, covers the entire life of the guarantee, and long-term financial vulnerability can create stress, particularly if your circumstances change. So that then leads to the next question of how long does a guarantee last? Well, guarantees have longevity and remain enforceable until the guarantor is released by the bank or the party to which the security has been given. This might not happen until the loan is completely repaid, the underlying asset might be sold, or perhaps the bank may release expressly the guarantor from their obligations. That is particularly so if the loan-to-value ratio is very good, or if the bank and party, the borrower, look to alternate security. So even if the relationship with the borrower deteriorates, and that might be the borrower might be a business partner, friend, family member, or spouse, the guarantor will remain liable for the agreement or the promise to the bank until formally released. Therefore, personal guarantees can prevent challenges in the event of marital breakdowns, as separation or divorce doesn't automatically mean you're released from your obligations as guarantor. And that's really important to keep in mind, because giving guarantees for your spouse is quite common, and particularly if your spouse is the business owner and a director of a company. However, if your marital or spousal relationship breaks down, you remain on the hook unless you're expressly released, and it's important to keep that in mind and to deal with it. So, who is the first port of call when things go sour for the bank? Well, often lenders are not required to first recover or attempt to recover the outstanding amount from the borrower. The lender may choose to pursue the guarantor directly. As such, understanding the recovery terms is critical. And I often say to people that the bank, or whoever the secured party is, will typically go to where it is easiest for them to pursue. So if the borrower has minimal assets, or recovering or pursuing them would mean selling the underlying business, then that's, not the easiest way to recover the debt. However, the guarantor might have a significant amount of funds available, or a home without security over it that is easier to sell. So the bank will go, the path of least resistance. But it's not all bad news. So as a guarantor, you are entitled to be kept informed about the borrower's loan and repayment progress, and also have a right to request that information from the lender or the secured party at any time. Keeping an eye on the borrower's financial health and repayments can help you, particularly if you're concerned about their financial status and you're not involved in the actual borrowing entity. So if you are the guarantor but you're also the director of the company, then of course you know what the company is doing. However, if you're a third party guarantor and not across the day-to-day operations of the borrower or their financial status, keeping a closer eye on it might be worth it. So what practical precautions can you take? Well, firstly, seek independent legal advice. So it's important to have the guarantee documents reviewed by an independent lawyer who can explain the risks and ensure you understand your obligations. It is also often the case that the bank or secured party will actually require you to obtain that advice. So there may not be a way out of it. And to be clear, that is something we can certainly help with at Vitality Law Australia. Secondly, limit your liability. So you should try to explore options or discuss alternatives to limit your financial exposure, such as setting a cap on the guaranteed amount, requesting an expiry date, or perhaps looking at other forms of security. And thirdly, you should monitor regularly. So stay informed about the borrower's loan repayments, and therefore being able to anticipate potential issues and act quickly if something does arise. Offering a personal guarantee is undoubtedly a significant financial decision that should not be made lightly. If you are providing an independent guarantee, you should take into account the responsibilities that you have in giving that, and make sure you assess your financial risks carefully. Hope that's been helpful for you. Until next time, take care.